Welcome back to the Fuse Chronicles channel. In this episode, we will be highlighting the legal landscape of abortion in the United States has undergone significant transformations, particularly following the Supreme Court's decision in Dobbs v. Jackson Women's Health Organization in June 2022. This landmark ruling overturned the nearly 5-decade precedent set by Roe v. Wade, thereby eliminating the federal constitutional right to abortion, and delegating the authority to regulate abortion laws to individual states. Consequently, a diverse array of state-level abortion laws has emerged, ranging from complete bans to protective measures. If you are interested in moving to another city in the United States, this episode provides a comprehensive analysis of the current abortion laws in various U.S. states, elucidating the specific provisions of laws, presenting the perspectives of civil rights groups regarding these legislative measures. In the aftermath of the Dobbs decision, numerous states have enacted laws that significantly restrict or entirely prohibit abortion services. As of February 2025, approximately 22 million women and girls of reproductive age reside in states where abortion access is heavily restricted or altogether inaccessible. Alabama has implemented one of the most stringent abortion laws in the nation. The state's legislation criminalizes abortion at any stage of pregnancy, with exceptions solely to prevent a serious health risk to the mother. Performing an abortion is classified as a felony, carrying severe legal penalties for healthcare providers. Louisiana enforces a near-total abortion ban, permitting the procedure only when necessary to prevent death or substantial injury to the mother. Notably, the state has taken legal action against out-of-state medical professionals who provide abortion services to Louisiana residents via telemedicine. In a recent case, Dr. Margaret Carpenter, a New York-based physician, was indicted for prescribing abortion medication to a Louisiana resident, highlighting the state's aggressive stance on enforcing its abortion laws beyond its borders. Texas has enacted a law that prohibits abortions after approximately 6 weeks of pregnancy, a point at which many individuals may not yet be aware of their pregnancy. The law uniquely empowers private citizens to file lawsuits against anyone who performs or aids and abets an abortion, effectively deputizing individuals to enforce the ban. This legislative approach has sparked considerable debate and legal challenges. Oklahoma enforces a comprehensive abortion ban, criminalizing the procedure at any stage of pregnancy. Exceptions are limited to cases where the mother's life is at risk. The state has also pursued legal action against individuals involved in facilitating abortions, including those who provide information or assistance to women seeking the procedure. Mississippi's legislation bans abortions after 15 weeks of gestation, with exceptions only in cases of severe fetal abnormalities or risks to the mother's life. This law was central to the Dobbs v. Jackson Women's Health Organization case, which ultimately led to the overturning of Roe v. Wade. Missouri has implemented a law that prohibits abortions after 8 weeks of pregnancy, with no exceptions for cases of rape or incest. The law includes provisions for criminal penalties against healthcare providers who perform abortions beyond the specified gestational limit. Arkansas enforces a near-total abortion ban, allowing the procedure only to save the life of the mother in a medical emergency. Performing an abortion in violation of this law is classified as a felony, subjecting healthcare providers to significant legal consequences. Kentucky's legislation prohibits abortions after 6 weeks of pregnancy, with exceptions solely to prevent death or serious injury to the mother. The law imposes strict penalties on healthcare providers who perform abortions beyond the permitted gestational period. Tennessee has enacted a law that bans abortions after a fetal heartbeat is detected, typically around 6 weeks into pregnancy. Exceptions are limited to cases where the mother's life is in danger or to prevent substantial and irreversible impairment of a major bodily function. Georgia's legislation prohibits abortions after a fetal heartbeat is detected, approximately 6 weeks into pregnancy. The law includes exceptions for cases of rape, incest, or when the mother's health is at serious risk. Civil rights organizations have expressed profound concerns regarding the restrictive abortion laws enacted in various states. These groups argue that such legislation infringes upon fundamental human rights, including the rights to privacy, bodily autonomy, and access to essential healthcare services. The American Civil Liberties Union has been at the forefront of challenging restrictive abortion laws, asserting that they violate constitutional protections. The organization emphasizes that decisions regarding abortion should be made by individuals in consultation with their healthcare providers, free from governmental interference. The ACLU continues to advocate for reproductive freedom through litigation, public education, and legislative efforts. Human Rights Watch has characterized the current state of abortion access in the U.S. as a human rights crisis. The organization highlights that restrictive abortion laws disproportionately affect marginalized communities, including low-income individuals and people of color, exacerbating. Planned Parenthood, a leading provider of reproductive health services, has vocally opposed restrictive abortion laws, arguing that they endanger individuals' health and undermine personal autonomy. The organization provides resources and support to individuals seeking abortion services and engages in legal challenges against laws that impede access to reproductive health care. The Center for Reproductive Rights has actively challenged restrictive abortion laws in court, asserting that they violate constitutional and human rights. The organization emphasizes that access to safe and legal abortion services is essential for gender equality and fundamental freedoms. The center continues to file lawsuits challenging abortion bans, advocating for judicial intervention to protect reproductive rights. Public reaction to state-level abortion bans has been mixed, with strong opinions on both sides of the debate. While conservative lawmakers and anti-abortion groups have celebrated the rollback of Roe v. Wade, many citizens, healthcare providers, and civil rights groups have mobilized against these restrictive measures. In response to restrictive abortion laws, some states and federal lawmakers have introduced legislative measures aimed at protecting reproductive rights. States such as California, New York, and Massachusetts have enacted shield laws to protect abortion providers and individuals who seek abortion care from out-of-state legal repercussions. These laws prevent cooperation with investigations or extradition requests from states that criminalize abortion. Congressional Democrats have repeatedly attempted to pass federal protections for abortion rights, such as the Women's Health Protection Act, WHPA. However, such measures have faced significant opposition and have not passed into law. Some members of Congress have also introduced bills to codify abortion rights at the federal level, ensuring uniform access regardless of state laws. Organizations such as Reproductive Freedom for All, formerly NAAL Pro-Choice America, the National Organization for Women, NOW, and If, When, How, Lawyering for Reproductive Justice have ramped up advocacy efforts. Strategies include lobbying lawmakers, supporting abortion funds, and mobilizing public protests. Multiple lawsuits have been filed against state abortion bans, arguing that they violate state constitutions or fundamental human rights. In some cases, courts have temporarily blocked or weakened restrictive laws, while in others, judges have upheld them. Civil rights groups and medical professionals have raised alarms about the consequences of restrictive abortion laws, highlighting their impact on public health, socioeconomic inequality, and legal precedents. Studies indicate that maternal mortality rates have risen in states with strict abortion bans, particularly among marginalized communities. Doctors report hesitancy in treating pregnancy-related complications due to fear of legal repercussions, leading to worsened health outcomes. Low-income individuals, people of color, and rural residents face heightened barriers to abortion access. Many must travel hundreds of miles to access care in states where abortion remains legal, incurring significant financial and logistical burdens. There are enormous legal ambiguity and criminalization related to vast aspects of this field. So much so that healthcare providers face uncertainty about what constitutes a life-threatening emergency, leading some hospitals to deny or delay care. Women who experience miscarriages or stillbirths have been subject to investigation in states with strict abortion laws. The landscape of abortion laws in the United States remains deeply polarized, with some states imposing near-total bans while others move to safeguard reproductive rights. Civil rights groups continue to challenge these restrictions, emphasizing the importance of bodily autonomy, healthcare access, and legal clarity. The battle over abortion rights is far from over, as ongoing legal challenges and legislative efforts shape the future of reproductive freedom in the US. Don't forget to like, subscribe, and hit that notification bell to stay updated on specific court cases or political strategies being used to challenge these laws. Until next time, stay informed and stay engaged.